Hey, my name is Nomfumdo Jele from the Law Society of South Africa. I'm joined by Eunice Masipa, who sits on the Law Society's House of Constituents, discussing part 2 of the Divorce Backlog project. Welcome, Eunice.
Thank you so much for having me, Nomfumdo.
You're welcome. Okay, as explained in part 1, the purpose of the project is to fast-track unopposed and settled divorces to get finalized and to fast-track opposed divorces with the possibility of mediation. All right, Eunice, can you please explain which rules regulate notice of withdrawal in the magistrates and high courts?
Okay. In the magistrates court, the notice of withdrawal is regulated by Rule 52A of the Magistrates Courts Act. Now, Rule 52A sub-Rule 1 prescribes or regulates the manner in which the notice must be served and to which parties the particular notice must be served. Now, the notice must be served to such a party to whom that attorney was acting on their behalf. It must also be served to the clerk or the registrar of the court and to all other parties to that particular proceedings. In the High Court, the notice of withdrawal is regulated by Uniform Rule 16, sub-Rule 4A. The rule stipulates that when an attorney to a proceeding acting on behalf of a client ceases to act on behalf of that particular client, that attorney has to serve a notice, and that notice must be served to the registrar of the court. It must be served to such a party on behalf of whom the attorney was acting, and to all other interested parties to the proceedings. That particular notice should be served via email, via fax, and or registered mail.
Are there any examples of where the courts have commented on why it is important to withdraw as attorney of record?
Yes, there are examples. There is a particular judgment which is relevant to this in this context. The correct citation is available on SAFLI, but the parties to the judgment include Said and Another versus the Road Accident Fund, Olin versus the Road Accident Fund. The judgment was handed down on the 4th of March 2021, and that particular case is available on SAFLI together with the correct citation. Now, in this particular judgment, the court confirmed that as a general principle, but subject to certain exceptions, a client is entitled at any time to put the end of an attorney and client relationship. Upon his so doing, the attorney must also accept the termination, the attorney who was on record. The court also stated that the attorney's function is to understand his client's problem, and where he knows that counsel will be briefed, to go to a reasonable extra mile, and when there is time available, not only to grasp the fact, but also to investigate the legal questions involved. Rule 16 makes it plain that an attorney, when acting for a litigant, is required to place himself on record and in accordance with the rule, which is Rule 16 of the Uniform Rules. Now, this serves an important notice as well, not only for other parties involved for an attorney to withdraw and to serve that particular notice, but for the protection of the attorney himself, as this judgment illustrated.
And could failure to file a notice of withdrawal land an attorney in trouble with Legal Practice Council?
Yes, definitely. An attorney can land in trouble with the Legal Practice Council, because in the judgment that I just referred to, the court directed that the judgment be delivered to the Legal Practice Council to investigate the conduct of the defendant's attorney in all the matters that were involved in this particular matter. So an attorney can indeed get into trouble with the Legal Practice Council. So it is very important that when an attorney withdraws, such a notice is served to all the relevant parties as prescribed by the uniform rules of the particular court.
Thank you so much, Eunice.
Thank you so much for having me.